My name is Mike Stooksbury. I represent the appellant in this matter, Timothy Lee Johnson.
You might need to speak up a little bit. I'm hard of hearing.
I apologize, Your Honor. I don't think I was close enough to the microphone. My name is
you.
Mike Stooksbury. I represent the appellant, Timothy Lee Johnson, in this case. May it please the court, this is a termination of parental rights case. I know the court is plenty aware.
Rebuttal time.
You're right, Your Honor. I apologize. Can I have 2 minutes of rebuttal time?
2 minutes, thank you, and thank you, Judge Stafford.
I'm always there for you.
Very good.
Your Honors, this case, like I said, is a termination of parental rights case. I know the court is well aware of the statutory groundwork behind that. So I'm just going to jump right into the facts very quickly. Heavenlee J was born on February 28, 2023. Almost immediately there was a referral to DCS as to the mother. That was investigated and the case was supposed to be closed. However, March 22nd, Heavenlee J visited Vanderbilt University Vanderbilt Medical Children's Hospital and weighed 5 pounds 11 ounces, which was less than her birth weight, 6 pounds 5 ounces. Accordingly, the hospital made a referral to DCS. That was investigated again, and it was shown there were some issues with the feeding of the baby by the mother, and then the grandmother is also helping out. But what we're really here to talk about is the father, who, of course, as the court I'm sure understands, also has a duty to make sure this child is fed. Accordingly, the child was removed from care about on March 28th, when the child was right at a month old. And then just a little over a month later, on May 5th, the father was arrested for a violation of the sex offender registry that had occurred several years before in 2020. Now, the father went through and got his issues straightened out, got out of jail, started working with the department to complete some of his action steps in his permanency plan. He completed a parenting assessment and was deemed to have moderate parenting knowledge, but kind of hit a snag after it came to light that he was living out of state, and that I think there's some dispute in the record as to whether the DCS refused to pay for it, or whether he could have come in state and gotten services even though he was out of state. But those services...
My recollection is that there was an argument by father that he was not permitted to leave the state of Kentucky except for court appearances.
And that's right, Your Honor. Okay. And I will certainly get to that.
Didn't the trial court find that DCS made reasonable efforts?
They did find that they made reasonable efforts, Your Honor.
Are you contesting that?
I suppose as a part of my argument I am, although I did not overtly do so in my brief.
Okay.
Either way, I'll just go ahead and move on to kind of the meat of my argument. First of all, the continuance. It was sort of up in the air in the week leading up to trial whether father was going to appear. Apparently he'd been served an eviction notice or something. He was moving, and not through his choice. And accordingly, he let his attorney know and let DCS know that he was moving. And on the day of trial, he had contacted his attorney and said, "I'm still moving. I can't make it. Is there any way we can get a continuance?" Essentially.
He contacted whom? He
contacted his attorney, who at the time...
I take it was not you.
It was not me. I was not the trial court attorney.
Okay.
It was another attorney at my firm.
Okay. What I was curious about was how did this, since father did not appear for trial, how did any of this information and request for continuance even come about?
Well, Your Honor, from what I understand, it was essentially through through his trial attorney. He contacted him and said, I'm not able to be there. I'm moving because of this, not by my choice. And accordingly, that his trial attorney made a motion on the day of trial at the very beginning for a continuance, and that was denied.
So in essence, the whole of the evidence was the attorney saying, Father's contacted me, this is what he says, I need to continue this case.
Yes, Your Honor, that is the case. Accordingly, it's our argument that the court abuses discretion in not granting that continuance. However, based on the other three factors I'd like to argue, I'm going to go ahead and move on to my next factor, or my next point. And that's the abandonment by wanton disregard. As the court knows, abandonment under the statute can come about several ways, and one of those is in the case of an incarcerated parent. According to, I apologize. According to Tennessee Code Annotated 36-1-113, and when it's defined under 36-1-102, 1A 4, when a parent is incarcerated at the time of the filing of the proceeding, essentially it shifts the window, because normally we have a 3 to 4 month window at the filing of a petition for abandonment. In this case, it's 3 because the child is under 4 years of age. That window shifts to be at the time of incarceration. And so if we look at the dates when father was incarcerated and when the child was born, that was less than 3 months. The child was born on February 28th, and the father was arrested on May 2nd. And while that does fall 3 calendar months, in terms of real time, actually I think it was May 5th, I apologize, that's really only just a little over 2 months of time. Now if we want to consider the pregnancy of the child in that 3 months, there's nothing really in the record that shows, other than when he signed the birth certificate, there's nothing in the record that actually shows that he knew the child was his, that he was, he knew the child was his at that time. Additionally,
what was he incarcerated for?
It was a violation of the sex offender registry from 2020.
From 2020?
That's correct.
So the violation, his wanton act, occurred in 2020?
That's right. His wanton act occurred before the child was born, was conceived, and it's unclear in the record whether he even knew the mother at that time.
That's what I was getting to, whether he could have known at the time he violated the law that the child was in existence.
Certainly.
And the answer is no, he could not.
That's absolutely correct, Your Honor.
Okay.
As to the next ground, which is persistent conditions, the child, the statute says the child has to have been removed from the physical or legal custody for at least 6 months. That's there. However, there has to be the conditions that the child was removed for have to be persistent. In this case, the reason the child was removed was for 2 reasons: nutritional neglect and failure to thrive. Now, the second reason is kind of dependent on the first reason, but both of those reasons are based on the actual care of the child itself or herself. And here, there's obviously the child is not in his care for those conditions to persist. Now, there's some argument by the department that there were some other issues that the child wasn't overtly removed for, but that are pertinent. And while I agree they may be pertinent in a best interest analysis or something like that, in this case, we're relying on why the child was removed, and she was removed because of those two specific reasons. A couple of those reasons that just very quickly, a couple of those reasons that the the state tries to uphold as a reason for the removal, or a reason for persistent conditions, is the father's home and the condition of it, and the availability of a bed for the child. And I'll just point out, as I talk about in my brief ad nauseum, that the caseworker only spent about an hour and a half in totality in contact with Mr. Johnson throughout the entirety of the case, not just when she went to visit him the one time she went to visit him at his home, but in totality of the case.
Was that in Kentucky?
I believe it was, yes. So it's kind of our argument that those persistent conditions are very hard to prove if you don't know what the conditions are, because you never went back. As to the third ground that Mr. Johnson was terminated on, it's the failure to manifest an ability and willingness under Tennessee Code Annotated 36.1.113 G14. So a parent or guardian has failed to manifest by act or omission ability and willingness to personally assume legal and physical custody or financial responsibility of the child. Placing the child in the person's legal and physical custody would pose a risk of substantial harm to the physical or psychological welfare of the child. And like I was stating in the last bit there, while Mr. Johnson did not visit the child during that period, and as Judge Bennett alluded to, he was unable to come to Tennessee from Kentucky because he could only leave the state for court. And that became an issue, from what I understand the record, a few times, but that came out in testimony from the DCS representative there, that he was unable to come down, and it seemed like to me they were kind of unwilling to work with him in getting the child up to Kentucky. In addition, the court also, in its order, lists some very speculative reasons as to why he hasn't assumed responsibility or legal physical custody of the child. One of those is that he hasn't seen his child in 2 years, so he can't even pick her out of a lineup. Your Honor, that was based on a statement by the DCS representative at the trial, and I mean, that's incredibly speculative, and I don't think a basis for why someone should be making that argument. Thank you, Your Honor.
All right, thank you. We'll hear from you on rebuttal. Good morning.
Good morning, Your Honors, and may it please the Court. Jordan Cruz for the Department of Children's Services. This termination case is about a 3-year-old special needs girl who has not seen her father since she was 2 or 3 months old. It's also about a father who has been completely absent in the child's life, has done nothing to reunify with the child, and has not provided any support for her in any way. I'd like to first go over a few facts that are relevant to all the grounds for termination in this case, which are wanton disregard, persistent conditions, and failure to manifest an ability and willingness to care for the child.
With regard to wanton disregard, how can that possibly be a ground if his act occurred before the child was even a glimmer in anybody's eye?
As far as the criminal act at issue for the wanton disregard ground, I agree that it's not entirely clear. It's clear that he was charged with the offense in 2020 before the child was even conceived. I agree with that. But as we state in our brief, there are other grounds to other reasons to affirm that ground for termination, because according to this court's decision in Audrey S., we don't just look at the criminal behavior of the parent, we also look at the parent's failure to adequately provide support for the child or adequately provide supervision for the child. and those factors are certainly present here. The father never paid child support throughout this 2-year case, ever. Never even offered to pay support for the child, didn't give her any monetary support or any in-kind support ever. He also failed to properly supervise this child. This child was taken into custody after she was determined.
There are specific grounds for not paying support and whatnot. Are you saying not paying support also is wanton disregard?
Yes,
Okay.
it is, Your Honor. I can't tell you why DCS didn't allege the ground of failure to support here. I certainly would have, because it was proven by clear and convincing evidence.
Did the trial court rely upon these grounds in the method that you are suggesting to us we should?
I would need to go back and look at the order, Your Honor. I'm not sure on that.
I don't think the trial court did. I think the trial court relied upon the underlying criminal offense and the violation of probation.
Yeah.
What about the violation of probation? Does that get you, does that work in your analysis?
The violation of probation. So the charge that he received in 2020, that charge itself would not work for wanton disregard, Your Honor, because
Okay.
it happened before the child was even.
So if it's not the underlying offense itself, a violation of probation for the underlying offense would not qualify either. Is that correct?
I believe that's right. The criminal act, so for the purposes of wanton disregard, the parent needs to know, the father needs to know of the child's existence for that act to count as wanton disregard.
Do we know when he knew the child was in existence?
I think and I believe Father's counsel concedes that he certainly knew when the child was born in February of 2023. The record's not clear on if he knew he did live with the mother. So I think it's reasonable to infer that he knew of the child's existence when she was pregnant, but I don't think that's
Mother
relevant
didn't testify, right?
I'm sorry?
The mother did not testify,
She did not, Your Honor. She surrendered before trial.
and obviously the father wasn't there, so he didn't testify.
That's right. But he is on the birth certificate, and his DNA testing confirmed that he is the biological father.
Correct. No, I'm not questioning that. I'm just trying to figure out when he knew the child was, or what the evidence shows as far as when he knew the child was in existence.
Yep. And I would submit that at the time of the child's birth, at the latest, because he did live with the mother and the child, and he is on the child's birth certificate. As far as the other grounds for termination, persistent conditions and failure to manifest, as I said, there's some facts that are common and relevant to both grounds for termination. As I mentioned before, he never provided any support whatsoever for this child or even offered to support this child. He never even asked about this child. He never inquired about her well-being, and I would like to remind the court, this case went on for 2 years.
Well, again, is that what the trial court relied upon for the persistent conditions?
I believe so, Your Honor. And again, I didn't bring the order up here, but I believe the court did make findings of fact related to the evidence that I'm giving and will give during this presentation.
Is that consistent with why the child was removed?
No, the child was removed for failure to thrive and nutritional neglect, and so I'll focus on persistent conditions for now. That condition, I'll just say this first. So the ground does not focus solely on the conditions that led to removal. The court can also look at other conditions that may have arisen after the removal that would make it likely that the child would suffer neglect or abuse if returned to the parent. Both of those sets of conditions are present here. The original conditions that led to removal, the child's failure to thrive and nutritional neglect, had not been remedied because the father didn't take any steps to become or to get training on becoming a better parent and improving his parenting abilities. For example, he did not complete parenting education, which was recommended by his parenting assessment. He did not go to any of the child's medical appointments, in part because he's a convicted sex offender, is not allowed on the campus of the child's specialist that she saw at Vanderbilt Children's Hospital.
Did the trial court make any findings regarding the inability of the father to be able to cross state lines or to come to Tennessee? Let me say it another way.
I don't believe the trial court made findings on that issue, but I will say, and I was going to get to this point later, the The father submits that he was not allowed to come to Tennessee unless it was for court. That's not really supported by the record, Your Honor. He did throw out that excuse as one of many excuses he had for not visiting the child. It was either he couldn't come to Tennessee because his parole officer wouldn't let him, or he was sick, or he didn't have transportation. There was one excuse after the other for why he couldn't visit this child. The testimony shows that he did have a probation officer, and that all he had to do to get to Tennessee was to arrange it with his probation officer. He had to let him know beforehand and make the arrangements with the probation officer. Father never did that, and it looks like he never even attempted to do that in this case.
Let me go back to just what you said. You said the proof shows. Father didn't testify. So how did this even come into evidence?
The caseworker had spoken to the probation officer
Okay.
and testified.
Okay. And that's what the probation officer testified to.
The probation officer did not testify. The
Okay,
caseworker
excuse me, the
testified.
caseworker, I'm sorry.
Correct. She had a conversation, at least one, with the probation officer, and had basically said what I just explained, that father needed to work it out with his probation officer to get to Tennessee, and he just never did that. And so that's one of the reasons he didn't come to visit. That's one of the reasons he didn't come to Tennessee to complete the parenting education and the psychological assessment that would have helped him improve his parenting abilities. But he never did that. So that condition persisted. There were other conditions that would have caused the child to be subjected to neglect if returned to father. One, and again, he never financially supported this child, ever, and didn't support her in any other way either. He also never had safe and stable housing for this child. He lived in a home with his mother that was not appropriate. Well, I should say, after he spent a few months in jail, he moved in with his mother, which home was not appropriate for the child, had nothing the child needed, and the father planned for the child to sleep in his bedroom, which contained a mattress, a space heater, and an ashtray, and that was it. About a week before trial, father moved. DCS asked where he was moving. Father never responded, never told DCS where he was going. So we didn't know where father was at the time of trial. As far as the failure to manifest ground, again, a lot of these facts overlap and are relevant to the failure to manifest ground. So I'll focus on the second prong of the failure to manifest ground, which is there a risk of substantial harm to the child if returned to father? And it certainly is. The father had not seen the child in almost 2 years by the time of trial. The child didn't even remember who father was. He was a complete stranger to the child.
The child could testify?
No, Your Honor. The child was
How does this come in?
that it was through the caseworker, or no, I'm sorry, the foster mother, Your Honor. I believe she testified that it appeared the child had no memory of father and did not even remember who he was. And also, failure to support throughout the entire case. The child didn't know who father was. The father did not have a safe and stable home for the child. All of those factors, alone or in combination, would show that returning the child to the father would pose a risk of substantial harm to the child. Moving on to best interest, again, it's clear from the evidence, father he didn't make any progress in this case. It would not be safe to return the child to father. But fortunately, the child had done very well in her foster home. She is a special needs child. She required a lot of attention, a lot of medical care. She saw, I can't even count the number of specialists she saw. She was born with a lot of conditions and had to receive a lot of medical treatment. But she was thriving in the foster home as much as she could. She had closely bonded to the foster parents, to their daughter as well, and to the foster parents' extended family and their friends. She had made improvements. She gained weight very quickly once she entered the foster home. The foster parents took her to all of her medical appointments. They were right there by her side for all of her surgeries and hospitalizations. She was learning to talk. The child was at the time of trial. She was a happy girl and enjoyed doing things that toddlers do. And so the department submits that it was in the best interest to terminate father's rights and that the judgment below should be affirmed.
Thank you very much. rebuttal.
Thank you, Your Honors. I'm going to take just a couple of minutes, literally, to address some of the statements that the counsel for the department made. Number one, I think this was a point that was made by one of you about there being better grounds that this could have been pursued under. That's kind of my argument, is that I'm not saying that my client, the appellant, is necessarily world's best dad. There are some definite issues there. However, in this case, the department didn't pursue the right grounds to effectively terminate his parental rights. Additionally, I don't think the department pursued his development into being an appropriate father during the length of the case, which was one of the department's main arguments, is that he didn't make any progress during the case. Well, as I stated, Your Honors, the caseworker only communicated with him maybe an hour and a half in totality, which is what she testified to, throughout the entire case. And as I also explained in my initial argument, he's a man of limited means, and he lives out of state. And so the odds were stacked against him at the very beginning. So if we're relying on his training to become a good parent as the reason we're going to terminate his rights, when all those mitigating factors are present, I don't think that is a reason to terminate his rights. Accordingly, I would ask this court to overturn the lower court. I apologize, Your Honors. Thank you.
Thank you. Thank you both for your arguments. We'll take the matter under advisement. Call the next case, please.
Randy Arnold versus Camilla Sanders.